whether, because I see Gerald Conway already with the video on, and I would like to check whether also Professor Turmo is connected. I don't think so.
No, not yet.
Yes, so probably I prefer to just wait a couple of minutes to check, since I mean she's the second speaker of this afternoon. So just a few minutes.
Yes, okay. Hello, Rosario.
Hi, Gerald. Do you mind? I mean, just a few minutes, just in order for me to check for Professor Turmo.
Yes, no problem.
Professor Sigurella, just 2 words as a reminder for those who were not present today morning. Please consider that by taking part into the workshop, you accept to be video recorded, and we will publish the video recording in the website of the project. And I kindly remind you all also, if you could fill in the feedback questionnaire that I posted in my first message in the chat of the event. It's very important for us. And then send, please, back your answers to me. Many thanks.
Thank you, Amalia. So now we start. I hope Professor Turmo will join very soon. Our first speaker is Professor Gerald Conway, Professor of Criminal Law at the Brunel University in London, who is going to speak about investigation and prosecution of financial crime, a comparative perspective on institutional roles and responsibility. Before giving the floor to Gerald, please, I kindly ask to all the speakers to kindly stick on the planned time limit of 20 minutes, in order then to have the right time eventually to discuss and not to go too far late this afternoon. Gerald, you have the floor. Thank you.
Okay, thank you. I'm just trying to share my PowerPoint. So I'll just be a moment. Okay, hello, everybody. Can you see my presentation?
Yeah, Joe.
You can. Okay. Can you see me speaking as well?
Yeah.
You can. Okay.
Yes.
Okay. Well, welcome everybody to my presentation. I just to mention that I'm not actually a professor of criminal law, but I have a one of my main research interests is in criminal law, and I'm a long-standing member of ECLAN. So thank you for inviting me to speak today. The title of my presentation is The Investigation and Prosecution of Financial Crime, a Comparative Perspective on Institutional Roles and Responsibilities. And what I want to do in this presentation is to focus on who does what in the context of the investigation of financial crime, and to put it a bit in the context of the overall role of prosecutors and their relationship with the police. In particular, I'm going to consider Ireland as, if you like, the main reference point, and how Ireland could participate in the European Public Prosecutor's Office. Alongside the International Criminal Court, the EPPO is probably the best example of how comparative law and comparative procedure has actually been implemented in practice across different member states of the EU or across countries generally. The international criminal tribunals and the statutes under which they operate are the other main example of transnational criminal procedure that's grounded upon comparative law. Okay, well, to begin with, nationally organized dedicated prosecution entities are in historical terms quite recent. They only emerged in the 19th century. And even though there are a variety of prior examples of prosecution type, if you like, officials, or the exercise of a prosecution role by various types of officials, a centrally organized prosecution authority is quite a new development in broad historical terms. Traditionally, it was victims who prosecuted in the majority of cases. And it's only with the Napoleonic era in France that the first modern national prosecutor developed. I'm going to focus on Ireland in what I say, as I say, in the context of Ireland participating in the EPO. And I'm going to make some brief references to the UK, France, Sweden, and Brazil toward the end to illustrate a more general point that there's quite a variety of possible approaches across the inquisitorial and adversarial traditions, and that it's not always helpful to typecast or categorize a particular procedure or particular approach as being within the adversarial or inquisitorial tradition, or as being necessarily associated with it, and something that has to be done that way in one of the traditions, one of the two broad traditions of criminal procedure. If anybody has any questions, feel free to ask me. As we go along, you can raise your hand or just, I cannot see you now because I can only see my PowerPoint. So if you want to ask a question, please feel free to intervene. Okay, so Ireland is now the only predominantly common law country in the EU, and key features of its criminal procedure that may be helpful to set out at the start are firstly a general adversarialism, a general approach of adversarialism, and a more recent trend towards a separation of powers between the police, the prosecution, and the judiciary. The police being responsible for investigation, the prosecution being responsible for the decision to prosecute and the conduct of the proceedings at trial, or the presentation of the case against the accused at trial, and the judiciary for overseeing the trial. I'll come back to the point about the separation of powers because it's important to considering Ireland's participation in the EPPO. The admissibility of evidence is much more regulated in the common law, largely due to the jury tradition. So this marks Ireland out particularly in the EU. In contrast, most civil law jurisdictions have a principle of the free admission and free evaluation of evidence, more or less, with some narrow exceptions. Although juries are a feature of the common law tradition, as is well known, the large majority of offences are triable summarily. And there are a range of offences that are triable either way. A summary trial in common law terms is a trial for a minor offence and it's not held before a jury. As I say, quite a range of offences can be triable either way, and sometimes the accused has a right of an election between either a summary trial, which has a lesser punishment, or a trial before a jury. And a final point worth mentioning, which is not something which is something specific to Ireland, and that's the use of a juryless special criminal court in certain categories of serious case. When thinking about Ireland and the EPPO, the two most relevant points from the list above are the first two, the principle of adversarialism, and this, not the first two. There's a mistake on my slide. I should say points 2 to 3. The historically more recent trend towards the separation of powers in common law jurisdictions, including in Ireland, and for there to be a distinct role for the police and prosecution. And secondly, the question of the admissibility of evidence, which is much more regulated, as I say, in the common law. Ireland did not initially participate in the enhanced cooperation establishing the EPPO. As I say, the two main issues or two main possible problems with Irish participation is firstly that Irish criminal procedure does not enable the prosecutor to instruct the police. And this is the point I made about a separation of powers. Normally people think of a separation of powers in a constitutional context. The trias politica, the judiciary, the executive, and the legislature. But it's also possible to apply a similar idea in this specific context of criminal procedure. And there might be some normative reasons why that's appealing, for somewhat a similar rationale to the reason for separation of powers in constitutional terms. Secondly, the mutual admissibility of evidence envisaged in the EPPO has been considered to be a problem for Irish participation. But as I'll discuss, the wording of the EPPO regulation seems to be flexible enough to accommodate Ireland being involved. The police and prosecutor relationship, as I mentioned, in Ireland is distinctive as a common law jurisdiction within the EU. And the essence of it is that the police submit a file to the prosecutor in more serious cases. The prosecutor can advise, if requested during an investigation, the police, but they generally don't advise about the operational details of an investigation. They might advise about some legal question that's put to them. It's the prosecutor who decides whether or not to prosecute, independently of the police, and the police will have acted independently of the prosecutor up to the point of submitting a file. So that's the expression that's used in Ireland. The Gardaí, the police, has submitted a file to the Director of Public Prosecutions, and there's no real overlap between those two stages. Once the file is submitted to the Director of Public Prosecutions, the investigation is considered to have been completed. And it's quite often the case that the Director of Public Prosecutions will decide not to initiate a prosecution because there's insufficient evidence, rather than that the prosecutor, the DPP as it's called in Ireland, the Director of Public Prosecutions, would go back to the police and ask them to investigate a particular point further. There's a practical division between those two stages of the process. The police can prosecute in Ireland in a very limited, in a limited category of cases. They can prosecute in summary offences. Now, as I say, numerically, that's actually a very big category. But when the police do prosecute in summary cases, they're subject to the direction of the prosecutor, but only in relation to the prosecution, not in relation to investigation. And that's set out in the Police Act, the Garda Síochána Act of 2005. Okay, so on this slide, I've included a quote from the government, from a minister in the Department of Justice about Ireland's participation in the EPPO, and this dates from 2021. And in this statement, the minister says, the fundamental difficulty that arises is that the Irish courts would not be entitled to exclude unconstitutionally obtained evidence. Under the EPPO regulation, evidence would potentially be admissible based on other member states' legal regimes and on the regulation itself. More generally, challenges arose in how the EPPO structures would have interacted with our common law regime and how institutions and practices have evolved. The EPPO was built primarily from a civil law base. So that identified the two concerns I've mentioned. Earlier this year, the now Minister for Justice, Jim O'Callaghan, spoke in the Dáil, the Irish Parliament, and stated that the Irish government was planning to participate in the EPPO. He said that at that time, when the PIF directive and the EPPO were being adopted, Ireland decided not to opt into the EPPO regulation, given that it represented a departure from our common law model of investigation and prosecution. So you can see there the concern with the different approach to investigation and prosecution in Ireland, the fact that the prosecutor cannot instruct the police, and that there's this division between the investigation and prosecution stages. I've already set out the essence of the role of the police relative to the prosecutor. Just to mention a couple of other points, there's some things I repeated on this slide. The Gardaí, or the police, have the power to investigate crime independently of the prosecutor. And the prosecutor is not involved in any way in the process of initiation of an investigation. So prosecutors don't refer criminal matters to the police. And the prosecutor is only involved at a subsequent stage when notified by the police or notified by a relevant agency, in the case of specialist investigation powers. Garda powers are set out across a range of legislation. There is a General Police Act, but it doesn't specify in very exact terms the powers of the police. Rather, it sets out overall functions. For example, it refers to crime prevention. So you have to look to the overall pattern of police powers and legislation to understand the scope of what the police can do in Ireland. However, that same act, as I mentioned, is clear that the power of the police or the Gardaí to prosecute is limited to summary offences and subject to prosecution direction in those cases. Previous to 2005, there was a broader common law power which is applied to the police, and it also applied to any victim or witness of a crime to act as a common informer. But the 2005 Act limited that power, which was not used very much in practice anyway by the police. The DPP is the term used in Ireland and the UK for the prosecutor, so we don't use the terminology of Procurator General. The DPP has an in-office solicitors division and also has contracted state solicitors in each county who do a considerable amount of summary prosecution work. And so in practice, the power of the continuing power of the police to prosecute in summary cases is not exercised very much. That's my understanding. The DPP in Ireland then is the prosecutor and is now a separate independent state agency or state authority. Prior to 1974, the prosecution function was a part of the Attorney General's office. Prosecution of Offences Act 1974 defines the function of the DPP relative to the previous practice. So you don't have a statutory definition of prosecution. The 1974 Act referred to the previous practice. As I say, there's no power on the part of the prosecutor to direct the police or the Gardaí, although sometimes the Gardaí do request advice on legal matters. So the standard process in Ireland in a serious case, which would be most fraud cases would fall into that category. I won't go into the jurisdiction of the courts when it comes to serious and non-serious cases or minor offences. But most fraud cases involving EU funds would fall into the category of serious offence. In those cases, a Garda file would be sent to the Director of Public Prosecutions after the investigation. And if it was decided to prosecute, the DPP would, if it was a serious case, hire an outside barrister to actually conduct the prosecution in court. And there's a panel of privately employed barristers who do contract work essentially for the DPP. Unlike the United Kingdom DPP, Ireland doesn't retain in-house prosecution advocates or barristers. In practice, the Gardaí and the DPP work largely independently of each other. There's relatively little sort of day-to-day engagement between the two offices or the two functions. Now that would be different for prosecutors who are attending a trial, but in, say, what's called the directing division, which is the part of the prosecutor that determines whether there should be a prosecution or not, they would have relatively little contact with the Gardaí about a specific file. There are a number of non-standard prosecution processes in Ireland, which I won't go into in detail. One example maybe to mention is that the Corporate Enforcement Authority has the power to prosecute summarily, and it has Gardaí seconded to its staff. So there's a quite close cooperation there between the prosecution authority and the Gardaí, but that's different to how the general prosecution works in Ireland. Okay, so how does this relate to the EPPO regulation? Well, the recitals to the EPPO set out quite a lot of background and detail to the working of the EPPO that's not actually in the provisions in the articles of the regulation themselves. So recital 30 makes it clear that it's European delegated prosecutors who carry out investigation in the member states. So you can see very clearly from that that's a contrast with Irish procedure. In Ireland, it's the police who do the investigation, and the prosecution are essentially not involved and cannot direct the police. Recital 34 makes it clear that the European delegated prosecutors will work to the instruction or under supervision from the permanent chambers and the European prosecutors. So again, that's clearly a contrast to the Irish approach. That's relevant to the question of the appointment of a European delegated prosecutor. And this is set out in recital 33, that notwithstanding their special status, the European delegated prosecutors should, during their term of office, also be members of the prosecution service of their member state. And should be granted by their member state at least the same powers as national prosecutors. Okay, so that's the first, if you like, obstacle to Irish participation in the EPPO. The second obstacle to Irish participation concerns the admissibility of evidence. Now, this is a relatively complex issue in Ireland. I set out on this slide the leading case, which is DPP, Director of Public Prosecutions versus JC from 2015. And there are two sort of broad situations where unlawfully obtained evidence is a problem or an issue in Ireland. The first is where there's been a breach of the ordinary non-constitutional law, and the second is a breach of constitutional law. In the first case, it's at the discretion of the trial court whether to admit evidence. So that would leave more flexibility for evidence from another jurisdiction. But the big problem would be the admission of evidence obtained unconstitutionally. And there's a quite complicated test as to how that works in Ireland. But essentially, the prosecution must justify evidence being admitted when there's been something unlawful about the circumstances of it being obtained. And when there's a deliberate and conscious violation of constitutional rights, it's harder to have the evidence admitted. So the question then would be translating that to our Irish participation in the EPPO. Arguments could be made that the circumstances of the obtaining of evidence in another member state would involve a breach of Irish constitutional due process if it was to occur in Ireland, and whether that could satisfy the test for admission under the JC case. So the general approach is that it's such evidence obtained deliberately and consciously in violation of constitutional rights is inadmissible, save for exceptional circumstances. There are also other rules of evidence in the common law whereby evidence is excluded routinely that is not so in other jurisdictions. And that the most important rule there would be the rule against hearsay. In other words, the requirement for there to be direct evidence or testimony presented in court. But that's not so unusual even in civil law jurisdictions nowadays. And there are practical ways in which perhaps that could be addressed. The EPPO regulation sets out a general principle of mutual admissibility of evidence, but it makes clear in recital 80 that it's is not insensitive to the existence of different legal traditions about the admission of evidence. And in particular, it says nothing in this regulation, in recital 80, it says nothing in this regulation may be interpreted as prohibiting the courts from applying the fundamental principles of national law on fairness of the procedure that they apply in their national systems, including in common law systems. That's at the end of recital 80, which starts with the evidence presented by the EPPO in court should not be denied admission on the mere ground that the evidence was gathered in another member state or in accordance with the law of another member state, provided that the trial court considers its admission to respect the fairness of the procedure and a suspect or accused person's rights of defence under the Charter. So there's a certain ambiguity in that provision in recital 80. It's deliberately a bit open-ended about the balance between national courts in which an EPPO prosecution will be brought, respecting national traditions of due process, or simply applying the minimum rights recognised in the Charter, but it clearly leaves scope for some application of a different national tradition. So the practical question is how far could that recital 80 be applied to accommodate the Irish tradition or an Irish practice when it comes to admitting evidence. Okay, I'm going to finish by making some brief references to comparative law. And the purpose of this really is to illustrate a point I made at the beginning, that it's not helpful always to have a very rigid understanding of the inquisitorial and adversarial models of criminal procedure. There's certainly nothing new about saying that. It's a sort of well-recognized point within the literature on comparative criminal procedure. But I think it's especially relevant when thinking about the EPPO, because the EPPO is really the main example of having to accommodate the two different traditions in practice. Apart from the example I've given of the Director of Corporate Enforcement in Ireland having police officers seconded to its staff, but at the same time having a prosecution power in summary cases, the main example in the common law of a combination of investigation and prosecution powers like you have in the EPPO is the Serious Fraud Office in the UK, which was established under the Criminal Justice Act 1987, and which both investigates and charges or prosecutes suspects, and it has its powers include the conduct of criminal proceedings. And in other words, it's responsible for the prosecution up until the end of a trial. So it's essentially both it's police and investigation and prosecution powers combined together. So that's a clear example of how a common law system can combine investigation and prosecution powers, and you could say that should be easily enough translated to Ireland participating in the EPPO. Now, one difficulty with that is that the EPPO requires appointees to be members of the prosecution authority and to have the same powers of the prosecutor under the national system. But in Irish criminal procedure, prosecutors don't have investigation powers. There's no equivalent in Ireland to the Serious Fraud Office. And so the Serious Fraud Office in the UK illustrates how something could be done in Ireland to accommodate that, but there would need to be some kind of special procedures or special regulations passed that enables the same person or the same entity to have both investigation and prosecution powers under Irish law. And there are different possibilities for doing that. Maybe one obvious possibility or apparent possibility would be for police with legal qualifications who could also be appointed as prosecutors to be appointed as European delegated prosecutors. That might be the most obvious way to overcome the traditional division in Ireland between investigators and prosecutors, and the fact that prosecutors are not essentially competent when it comes to investigation.
I kindly ask you to read the conclusion because you already ran out of your time.
Yes, I can. Yes, I will. I very briefly refer to France, Sweden, and Brazil, just in a few sentences. France has its own dedicated prosecution official, the Parquet Financier. It doesn't have, in general, the powers relative to the standard prosecutor in France. It's a dedicated specialist official rather than an entity with special powers. So the idea of having a specialist anti-fraud prosecutor is found both in common law and in civil law. Something like that could be applied in Ireland. Sweden is an example of a quite powerful prosecutor who can clearly instruct the police. Again, that's different to Ireland, where there's this distinction between the two roles. At the same time, the prosecutor in Sweden is it's institutionally distinct, and it's not seen as a problem of competence, if you like, that the prosecutor would instruct the police. So perhaps that's not such a big practical issue. Another example of a civil law country where the prosecutor and director of police is Brazil. And it's not seen as a question of sort of operational competence that prosecutors do have this power of instruction. So finally, as I say, the adversarial inquisitorial distinction is helpful from a conceptual or analytical point of view, but it shouldn't prevent thinking of more creative ways in which a country like Ireland could participate in an institution like the EPPO. It will take, however, some kind of departure from the standard procedure in Ireland to achieve that, to achieve a combination of police investigation and the prosecution power in one entity or one individual. Thank you.
Thank you, Gerald, for this, rich presentation. I think that you were actually, again, highlighting something that also has been very much discussed before immediately after the entry into force of the EPPO regulation, that is to say that all the many challenges in finding a common view among accusatorial and inquisitorial models, which are never really pure, I would say, model, and the crucial points concerning the role in the relation between prosecutor and police in the two systems, and something that also the question of admissibility of evidence, which is a real quite problematic question, a problematic issue, even, in all the systems, because of the very, I would say, open rule established in the regulation. Now I want to, give the floor to Professor Araceli Turmo. She's a professor of criminal law at the Université de Nantes, and she will speak about the implementation of the PIF directive and the regulation, the 95 regulation in France. And Araceli, à toi la parole.
Thank you very much. Thank you very much for inviting me to take part in this project. I'm sorry I wasn't able to attend this morning. I was teaching for 3 hours, but I did manage to catch the last couple of presentations. And I'm going to give a presentation that is perhaps going to be more focused on the directive, on the PIF directive, and its implementation in France, and some of the institutional aspects as well. Although I must say I'm very curious to hear our next speaker, because in terms of the EPO itself and the French delegated prosecutors, I wasn't able to find much information about their current practice, or indeed much information about ways of getting in touch with them for this project. So I'll be very curious to hear what they have to say, because all of the information I was able to find was just publicly available information on the EPO website. So when it comes to the implementation of the directive, and in general the fight against fraud and affecting EU financial interests, I would say that France, I mean, the implementation of that directive was part of this kind of 20-year-long process in France, where the law was basically brought up to date and made more compatible with the standards expected, in particular in international law and EU law. France had for a long time a relatively inefficient system of dealing with, in particular, corruption, public corruption, corruption in the context of public procurement, as well as various types of fraud, including those that most affect the EU budget. So a number of reforms took place over the 90s, 2000s, but I would say that the implementation of this directive was not a revolution, but it came as kind of one of the final steps to the current situation, where I would say that French law is starting to become more satisfactory in this respect. And this included some institutional reforms as well as reforms of the substantive law. In terms of the implementation of the PIF directive itself, the French approach led to pretty satisfactory results. I think some specialists were critical initially because of what they perceived as perhaps a lack of ambition and the way in which France chose to interpret its obligations under the directive. But most of the acts targeted by the directive were already criminal offences. Only very few new offences were created. One interesting case, though, is that a new customs fraud offence was created, which is a kind of, it's not as if the behaviours that were attached to this were not offences previously, but there was a creation of a kind of single offence, a single purpose offence that can be prosecuted in itself. Whereas beforehand you would have had to go through a variety of offences, and that would have caught some aspect of the behaviour maybe not as ideal. So this was an interesting change. Most of what changed really was the harshness of the sanctions that can be imposed through sentencing of those offences. The maximum penalties became higher. And what's interesting is that afterwards, after that stage of implementation, there was a further reform which in fact removed the special character of these offences as affecting the EU budget. So what France did was first implement the directive in making the maximum penalties harsher when they met the criteria of the directive for offences affecting the financial interests of the EU. And what happened after that was that pretty much overall, the harsher penalties became the default. And so the penalties became a possibility even for actions that didn't meet the criteria of the EU directive. So there are very few instances now where you would have a harsher sentence if an offence meets the PIF directive criteria. It's more just a harsher set of measures to combat those types of offences when they reach a certain level of seriousness, whether or not they affect the EU budget. There are very few, as I said, there are the French approach to this is that there are a variety of offences that may cover the actions affecting the EU budget that were targeted by the directive. But, for example, for fraud, I would say there are 4 or 5 different types, or maybe even 6 different types of offences that may, in French criminal law, that may be prosecuted as a response to an act that the directive would call fraud related to expenses that are not related to public procurement. So depending on the circumstances, we're going to use this or that instrument, but there aren't any offences that are specifically targeting those types of fraud. And by and large, the offences are going to be general purpose offences, not specifically targeting fraud related to fiscal matters or non-fiscal matters, etc. So it doesn't really apply in that way. It's not really specific in that way. Except, as I said, well, there is this new kind of criminal offence of customs fraud, which was created when implementing the PIF directive. No specific measures, to my knowledge, again, when it comes to VAT fraud. It's just, if it falls into the scope of specific criminal offences, then it will be prosecuted. When it comes to administrative punitive sanctions, it's also worth recalling that in France, the administrative side is completely separate from the criminal side. It's a separate set of courts. And so this may create different challenges than in other member states, depending on the legal framework and the institutional framework. In France, the administrative side, an administrative sanction will lead to potentially litigation in administrative courts and will be disconnected from criminal prosecution before criminal courts. However, there are rules regarding, for example, compatibility with nebis in idem when there is that kind of double track prosecution. Although France has signed a declaration meaning that the ECHR protection of nebis in idem does not apply. So the ECHR case law on nebis in idem regarding double track enforcement is not considered applicable to France by French Supreme Courts, but they do take it into account, and they, of course, have to take into account ECJ case law on that kind of double track enforcement. So they've tried to develop their own approach. There's been a lot of variation, I would say, over the past 2 decades on that issue, so it's not entirely clear what the law currently is. But there have been some efforts recently to construct an approach that makes it possible to comply with both standards of the European courts, while not giving up on the idea of double track enforcement when it's seen as useful. When it comes to offences related to corruption, again, I would say French law is currently compatible with existing EU law. And with regard to the proposal for a directive on combating corruption, again, I found that to a significant extent, French law already seems to be pretty much up to speed. in many relevant ways, although presumably, I mean, and I'm not going to go into the detail, but some aspects would need to be adjusted. But I think that in taking into account the reforms that took place over the past 2-3 decades and picking up speed in the last 10 years, I would say that France has a pretty robust legal system when it comes to the substantive law to fight that type of corruption, etc. Some of the issues will come from actual implementation and investigations. And here it's more a matter of practice. And in this respect, it's pretty difficult actually to carry out extensive research on the French system. One reason being because some of the law is very recent. I wasn't able to find much litigation because litigation hasn't reached the Supreme Court yet. And in France, it's very, very hard to look for judgments of first instance courts. We don't have a public repository of judgments of first instance courts. Even courts of appeal, sometimes their case law might be hard to find. So unless a specific judgment has been noticed and reported in some law reports somewhere, it's actually very hard to find the information. So I was able to find some case law, and in that respect, I would say the evidence is that French courts are using EU law instruments, but I can't find any interesting case law, as it were, in terms of judgments that really tackle issues of interpretation, etc., that were mentioned earlier in this workshop, because to my knowledge, nothing has reached the Supreme Courts, and there isn't much case law to be found. So you really need to be active before the courts to be aware of what the courts are doing. If you're just a researcher like me, there's only a limited amount of information you can find. I don't know how much time I have left. Okay. With regard to EPO, as I was saying, EPO was, it was very difficult to find any sources. So that's something, as I said, I'm really looking forward to hearing what the next speaker will have to say. Interestingly, France has really made an effort in the past few years to improve the institutional structures with regard to the fight against fraud affecting the financial interests in the EU and the fight against corruption. There have been, for example, working arrangements signed between EPO and bodies such as the MICAF, so that would be the Inter-Ministerial Mission of Coordination of Anti-Fraud. And so that is a service that exists only to improve the actions of the French government in the fight against fraud. But it's not a specific, so it's not part of a specific ministry. Its purpose is really to coordinate, and one of their roles is going to be, is specifically to be the anti-fraud coordination service as interlocutors for OLAF. But of course, this mission is not a prosecuting authority. And so they're just really about exchanging information. Again, EPO also has a working arrangement with TRACFIN, which is the Financial Intelligence Unit in France. And again, this is about sharing information. So these agreements were signed pretty recently, 2023, 2024. And so it's hard to find any sources that would justify making statements about their overall efficiency or usefulness. But there have been efforts to really make the most out of the tools that exist and improve cooperation between government offices in working towards this goal. I'm not aware of any significant conflicts of competence, again, between different investigative bodies, between EPO and other investigative bodies in France. I think the structure of the French judicial system and prosecutorial system in particular may help in this regard, because I think they're probably pretty used to competences being attributed in a rather specific way, so that there aren't many cases of conflicts of competence in general. But it would be interesting to hear in practice what it looks like. And there was one more thing I wanted to mention. Yes, sorry. The preventative framework in France is also, I think, pretty, in theory, pretty efficient now, but with limits. And I think the major limit is, in practice, do all public officials meet the requirements that are in theory there? But in theory, we do have now a French anti-corruption agency. So that's another body once again. So the French are very good at creating new bodies with new missions. So the effectiveness of the whole system may be discussed, but it does exist. And this agency in particular has the power to audit the existence and efficiency of codes of conduct and different types of programs and frameworks that have to exist, especially in companies over 500 employees, as well as in the public sector. And there's also a specific high authority that deals with public officials. This is the high authority for the transparency of public life. So that is the public wing of prevention of corruption of public officials. And again, they have reporting, there is reporting to them, and they also have some investigative powers, but they are not at all part of the prosecutorial system. That these are public agencies, so they're not going to go towards the criminal side of things, but they really are meant to work as preventative measures. And these are relatively recent developments. So again, it's a cultural shift. French law was very slow to catch up to a number of these things, especially with regard to corruption of public officials, and corruption of foreign public officials was a big one. For a long time, French companies were able to deduct corruption of foreign public officials from their taxes as expenses. So this is, I mean, it's a cultural shift. It's taking a bit of time, but I think probably in a few years we'll be able to start really studying the impact and seeing what changes have to be made. Thank you very much.
Thank you, Racheli. I think it was, I mean, very interesting also to look at the French, other French system. I also consider that you referred also to the other speaker. I will give her the floor, and then we open the debate. So that, so I ask, please, Mrs. Barral-Carnelli.
Yes. Do you hear me?
The floor.
Thank you. Allow me first of all to thank the University of Catalonia.
But I cannot see you. I don't know if it's. I cannot see you. But I don't know if it's.
Because my connection is not that well. So if I put on my camera, I'm not sure if the sun will go on. Yeah. Can I go on without my camera?
Yeah. Don't worry. It's okay.
So thank you for inviting me today to present the implementation of the directive of 2017 in the French legal system. Order of 18 September 2019 of the fight against fraud affecting the financial interests of the European Union by means of criminal law was aimed at the transposition of the European Directive of the European Parliament and of the Council of 5 July 2017 on combating fraud affecting the financial interests of the Union by means of criminal law. This ordinance amends a number of provisions of the Criminal Code to increase penalties for certain offences, notably bribery of public officials, when these offences result in harm to the financial interests of the European Union. Proceedings have been initiated on the basis of infringements of the interests of the European Union since the order entered into force. I propose to address initially the criminal protection of the financial interests of the European Union by combating fraud in the French legal system. Then the other criminal offences protecting the financial interests of the European Union and the definition of official, which is a little party, which is not as simple in the French legal system. Then the statute belt and jurisdiction and size and confiscation, and finally a few elements regarding the cooperation with the EPPO in France. To begin with the implementation of the directive regarding criminal protection of the financial interests of the French European Union by combating fraud, I must say that 5 breaches of domestic law indirectly protect the financial interests of the European Union. Those are embezzlement of public funds, forgery, tax fraud, fraud and bribery. In addition to this, fraud related to public expenditure is criminalized under domestic law as favoritism, corruption, and trading influence when committed in the context of public procurement procedures. The offenses of favoritism, bribery, and trading influence do not necessarily require that the perpetrator, understood here as the public official, obtain an illegal gain to be incorporated. Indeed, in the case of favoritism, the advantage derived from the obstruction of the public procurement procedure must not be enjoyed by the public official who committed the offense, but by others. In other words, one of the candidates for the procurement procedure. For passive bribery and trading influence, which means when the public official is behind the solicitation, it does not matter whether the perpetrator received a profit in exchange for his act or his abstention, so that the offense is characterized. These offenses are punishable by a high level of repression, in particular those of corruption and trading influence, both punished with a 10-year prison sentence and an extremely high fine as main evidence of the issues they represent in France. Furthermore, the public procurement codes provide that persons who have been the subject of a final conviction, notably for favoritism and misappropriation of public funds, are automatically excluded from defense and security procurement procedures. In addition to this, the code provides that failing a decision to order the exclusion of defense or security procurement procedures for a different duration, the exclusion from the procurement procedure applies for a period of 5 years. In the absence of precision, this measure is intended to apply to contracts whose value is below an European threshold, as well as to contracts whose value exceeds an European threshold. Finally, fraud related to revenue other than VAT are mainly criminalized as tax fraud by the General Tax Code. And I should indicate that only the offense of favoritism requires the demonstration of the existence of a prejudice as an unjustified advantage provided to others in order to be characterized. Bribery and trading in influence are former offenses that do not require proof of harm to be characterized. So it's a way to punish a lot of a lot of a person, because it does not require to be a prejudice does not have to be demonstrated. In accordance to the prescription of the 5th article of the directive, the Criminal Code specifically provides for the punishment of the principle for complicity in the commission of the offense. The accomplice is punished as the perpetrator of the offense, for example, for bribery or fraud. As regards offenses against the financial interest of the European Union, attempts to defraud, breach of trust, embezzlement of public funds, and money laundering are criminalized by the Criminal Code. Attempted smuggling is criminalized and strictly regulated by the Customs Code in the specific case of the contraband export of animals whose import is prohibited and those whose exit is prohibited or subject to duties. French criminal law criminalized also national, international, and foreign corruption in a formal manner. In other words, without proof of a result being necessary for the characterization of the offense. Therefore, the attempt at corruption is not punishable. The provisions of national law provide for an increase in the penalty incurred by the perpetrators of offense assimilated to fraud against the interest of the European Union. For example, fraud committed as an unorganized gang is punished with a sentence of 10 years imprisonment and a fine of 1 million euros, when simple fraud is punishable by a sentence of 5 years imprisonment and a fine of 315,000 euros. And another example, national, foreign, and international corruption are punished with a sentence of 10 years imprisonment and a fine of 2 million euros that may be increased to double the proceeds of the offense when corruption is committed by an organized gang, when simple corruption is punishable by a sentence of 10 years imprisonment and a fine of 1 million euros. As the next step, other criminal offenses are protecting the financial interest of the European Union through the definition of official. The public official is not defined in general terms in French criminal law. The concept of public official is broader than the single notion of civil servant. Are thus public officials liable to be prosecuted for the crime, for example, of corruption, persons vested with public authority who have the power of decision and constraint over individuals or things in the exercise of their temporary or permanent functions, it being specified that the functions may be administrative, military, or jurisdictional. Or persons holding a public elected mandate, such as local and national elected officials and elected administrative of public institutions. This definition of official includes de facto officials as elected office holders, and can also include individuals working within bodies controlled or participated by the state or other public entities. They are included only if they are entrusted with a public service mission, who are required to perform acts or to exercise the functions, the purpose of which is to satisfy the general interest without being vested with any decision-making power. The French legal systems recognize the criminal relevance of acts committed by third country officials involved in cases of corruption and misappropriation. Another important point about other criminal offenses protecting the financial interest of the European Union is the apprehension of corruption in the French legal system. Two kinds of corruption are criminalized by the Penal Code: public corruption and private corruption, which includes sport corruption taking place in the context of a public event or a horse race giving rise to bets so that the normal and fair conduct of this event or race is modified by the corrupt. These two kinds of corruption are distinguished by the quality of the corrupt. As for the public corruption, it requires that the breach of probity in connection with the official duties of the public official be accomplished. As for the private corruption, neither the corruptor nor the corrupt have the quality of official. In the French legal system, the corruption is criminalized as a formal offense. And the bribery pact is therefore concluded by the proposal of the corruptor alone to the public agent or the private agent without the latter accepting or giving to the proposal of offer, promise, gift, present, or any advantage. On the other hand, a bribery agreement is concluded as soon as a public official solicits an offer, a promise, a gift, a present, or a benefit, without the correct person having to subscribe to the solicitation. Thirdly, the French legal system does not provide specific rules for statute barred of offences affecting the financial interest of the European Union. Nevertheless, with regard to corruption and the misuse of public funds, a law of 2017 came to enshrine two procedural particularities that are also intended to apply when it resulted in the commission of these offences a harm to the financial interest of the European Union. The Code of Criminal Procedure provides that by the derogation from the rules of common law on prescription, the starting point of prescription runs from the days on which the offense occurred and be ascertained under conditions allowing the initiation or exercise of public action without, however, the limitation of period then exceeding 12 completed years. The same code determines a certain number of acts likely to interrupt the limitation period for offences. In this respect are, for example, included the acts of the public prosecutor and the civil parties seeking to initiate public proceedings, or an investigative acts emanating from the public prosecutor. As regards the suspension of the prescription for public action, the Code of Criminal Procedure provides for several hypotheses, such as in the event that the judicial decision which declared the public action extinguished with regards to specific offences was obtained through a forgery, prescription is suspended. And now I have a few elements regarding seizure and confiscation, and then the cooperation with the EPO in France. The Article 10 of Directive 2017 is implemented in the French legal system in the criminal code. This code provides that the additional penalty of confiscation is automatically incurred, notably for offences punishable by a term of imprisonment exceeding 1 year, except for press offences. Offences under national law falling within the scope of the repression of attacks on the financial interest of the European Union, all of which are punishable by a term of imprisonment equal to or greater than 3 years. In this sense, as regards the fight against attacks on financial interests of the European Union and against corruption, confiscation contains the sum and objects irregularly received by the perpetrator of the offense, with the exception of objects that may be returned to the victim of the offense. Since confiscation is a penalty, it cannot be imposed without prior conviction. So, and now finally, a few elements regarding the cooperation with the EPO in France. A few cases were investigated by the French EPPO in 2024. 9 cases were investigated, and in accordance with the competence of each of the EPPO and domestic investigate bodies, where heads of prevention aim to harm the financial interests of the European Union, national prosecutors shall relinquish their responsibility to the National Office of the EPPO. Thank you.
Thank you. I think that, I mean, now we have enough elements also to try to debate. Actually, I would like to somehow, I mean, put aside just the questions strictly related to corruption and to confiscation, because it will be the focus of future workshop and also for the final seminar, but also in, I mean, the perspective of trying to think about proposals for reforms or suggestions that you can, I mean, give in order to improve the situation of implementation at national level. I would ask some, I mean, above all, 2 questions to both the speaker concerning the French system. Professor Turmo, you referred to this probably, I mean, to this cultural shift concerning the corruption of a foreign functionary. I wonder whether you think that is, I would say, feasible or possible a similar cultural shift concerning relation between administrative and criminal, in the sense that the legislation, EU legislation, which is somehow also pushing with this category of punitive and non-criminal sanctions or quasi-penal sanctions, can somehow, I mean, I don't want to say fill the gap, because it's not a gap, but try to converge somehow also this separate world, the 2 separate worlds, that is administrative and criminal in France. This is one question. And the second question is looking at your report, there was an interesting reference concerning the situation of implementation of since 91, you have le délit de favoritisme. So there was, but for what I understood, such an offense requires a qualified subject, a qualified author. So that is to say that whenever it's a
I think that Professor Sicurella has some problem with the connection,
enacting
right?
some kind of...
Professor Sicurella, can you repeat the last words, because you had the problems with the connection with the internet? Still.
The French experts think it is possible a future in the short or medium period, have some, I would say, convergence between administrative and criminal sanctions, so that to also to comply with all the bis in idem case law. First question. And the second question was completely different subject, was concerning fraud in procurement procedure. I know that since 91 you have the délit de favoritisme, but which requires a qualified subject, qualified author. So would you suggest, or do you think that it is necessary in order to fully implement the directive, that new provisions or amendments of existing provision is necessary in order also to cover fraudulent behavior from a non-qualified author? So first Araceli and then Ele.
Thank you very much for both questions. On the second question first, on favoritism, I must admit I hadn't thought of that question. So I'm going to answer very quickly that I hadn't thought of the issue of non-qualified, so a non-qualified author. It is true, yes, that the délit of favoritism requires identifying Yeah, I can't answer that one. I hadn't thought of the question. On the issue of coordinating administrative punitive measures and criminal law, I mean, I didn't get into a lot of detail on this issue in the report because it was already very long, and nebis in idem, as you know, you could write a thesis on the issue of double track enforcement in any European country where the practice exists. I think it's definitely possible. I think recent case law in the French Supreme Courts definitely is trying to establish requirements so that there is a compatibility with nebis in idem. But in any case, I think there's always been this understanding that I mean, always, that all of that case law shows an understanding that you need to take into account whichever punishment comes first, basically, and the requirement of proportionality has also been influential in this case law. So in any case, the proportionality of penalties being a constitutional requirement is taken into account. So I think in this regard, there's no major conflict, but it's too early, I would say, to make any definitive conclusions from the case law, because it's been evolving over the past few years in both Supreme Courts.
Ms. Nahal Carnelli, do you wish to add something?
Yes, maybe on the second question, I did not think of this question as well. But if an unqualified person cannot intervene in proceedings that may give rise to favoritism situation, this person could be committed with fraud, because it would be like an abuse of our force quality. So maybe it cannot be punishable of the offense of favoritism, but with another offense, in my opinion.
But normally, I mean, if I remember well, I mean, escroquerie, I mean, you need an event, you need a damage. And for procurement fraud, this was the main, was that in principle, you don't need to have, I mean, then you can, you can establish that, but you can have the offense also without having a concrete loss or complete damage. You know, so this was the definition, the directive. So this was why I was wondering whether you think that a reform or amendments in this sense could be, could be considered necessary in order to fully implement the directive.
I cannot give an answer right now because I did not think of this.
Okay, sorry.
Question.
Okay, so probably we can. Yeah, but probably, I think it could be interesting also to think about also when your report will be turned in an article, because it's something that could be interesting in a comparative perspective. Now I go to Mr. Călinescu, which is from the representative of the Romanian Asset Recovery and Management Agency. He is on this workshop because of the absence of Professor Nitu, will be the sole representative of the Romanian system, and he will speak about bridging the PIF Directive 2024-1260 and the Warsaw Convention Protocol strategic implication for asset recovery and management offices. Please, you have the floor. Mr. Călinescu, I think I saw he was connected. I see among the participants, but
1 second, please. It will be ready. Maybe.
Yeah, don't worry. Just to
we will have a little issue with the connection. Sorry.
Yeah.
So it's my director, and he will reconnect in 2-3 minutes. Sorry for this problem.
Okay. Do you mind if I go on with the next speaker and then go back to you so that we have more time? Tell me what you prefer.
I think we can wait 1 minute. If it's not ready in 1 minute,
okay.
For another,
no, it's okay. It's okay. Just to understand which was the time you need. That's it.
Sorry. So you can proceed with the next presentation. And maybe we will.
Okay. So and you yes, and then I will call your name afterwards, so you will tell me if you manage. Okay.
If my director will not have the presentation, I will sustain it.
Okay. Thank you so much. So I give the floor now to Pim Gelooe. Sorry for the pronunciation, it's not very easy. He is professor of criminal law at University of Groningen, and he is going to make a presentation on the implementation of Article 3 of the PIF Directive in the Dutch legal system, an overview. Please, Pim, you have the floor.
Yes, thank you very much, Professor Sikora, and thank you very much to the organizers for inviting me. I would like to share my screen, but I think I'm not able to do that yet. So if you could make me a presenter, I'll be able to pull up a PowerPoint. In the meantime, I will tell a bit about what I'm going to do. My talk will resemble a bit like the presentations by Professor Zimmermann this morning and Professor Turmo from earlier in the afternoon. Because
can you get closer to the microphone or maybe raise the microphone, because it's not very easy to listen.
I can select another one. Is this better? Is this a better microphone? Okay. I will just go on. Could I be made a presenter so I can share a PowerPoint? maybe Amalia could do that. I'm not sure who is in charge of that.
Yes, I have just did it, and you should be able now.
Ah, excellent. Yes, thank you.
You're welcome.
So if I'm correct, you'll be able to see this now. I will just cover a couple of points from the Dutch perspective on the implementation of the fraud offense in the Dutch legal system. And it resembles the German situation and also the French situation to some extent, but in a slightly different manner. So I'll cover the Implementing Act of the 3rd of July 2019. We'll take a look at pre-existing legislation and the Commission notice of infringement. And then that was followed by new amending legislation. And I'll finalize with a couple of general observations. I will first show you the entire act by which the Dutch legislator implemented the PIF directive. This is everything. This is just it. It's a very tiny act. I will just zoom in a bit to the operative part. This is basically everything. The only thing that changed was that the maximum penalty of Article 323A was raised by 1 year from 3 years to 4 years. The other article is just there because it doesn't have to be on the list of cases that allow for pretrial detention anymore, because by having 4 years, it's on the automatic list. Article 323A is part of the implementation of the Fraud Convention. So the 1995 convention, it is misapplication of international funds that was implemented then, but then the maximum penalty was 3 years, so it had to be raised to 4 years. So this is basically everything that happened. So Rosario, when you mentioned earlier today that there was an extensive implementation procedure, that is correct. It just, so the government made a lot of analysis, made a very extensive analysis of the PIF directive and came to the conclusion that only one thing was necessary, just raising the maximum penalty of the misapplication of international funds by 1 year. So this is the result of that. That was necessary for compliance with Article 7, Paragraph 3 of the PIF Directive, the maximum penalty of 4 years. And there was no need, according to the government, to make any further amendments because all of the pre-existing legislation already sufficed. Well, what was that pre-existing legislation? Let's take a look. Most of the fraud cases are covered by the offense of forgery in Dutch criminal law. Maybe you're familiar with that. It's a bit of a typical offense, also called falseness in writing, Article 225, and it is very much a default offense for all fraud-related cases. It includes 3 variants. You can falsify an existing document, you can make up a fake document as if it is a real document, and the third variant is so-called intellectual falseness, providing wrong information, just providing an untruth in writing. That is basically the whole offense. It does not require any causation. It does only require that you intentionally provide false information in a way that is used in evidence for some kind of decision-making procedure. That is everything. It's a 6-year offense, and it has been used a lot in all kinds of domestic and otherwise fraud cases. We never really had a self-standing offense of fraud. It was never used. This was the basic offense, forgery. There's a tax fraud offense that's been there for quite a long time in the General Taxation Act. Which was for a long time, well, the most visible fraud offense. Very slowly in the second half of the 20th century, there were many acts adopted for social security purposes that all included a self-standing fraud offense. So we ended up at the end of the 20th century with dozens of fraud offences that were all spread out across the legislation. Then those were centralized in 2000 with basically two fraud offences in the criminal code. One on the intentional provision of false information, and the other on the omitting to provide relevant information. So those are as well within the scope of the PIF directive, and of course the misapplication of funds that was already there when the PIF convention was implemented. So these four offences altogether, according to the government, formed the implementation of Article 3 of the PIF directive. It was spread out over quite a lot of provisions. They were quite complicated as well. I have to say that by far the majority of cases would be covered by the offence of forgery, Article 225. That is such a broad offence. It's a kind of a catch-all offence that covers most of the cases, which was definitely also the intention of the legislator when sending a notification on the implementation. With regard to those other offences, the fraud offences that were introduced in 2000, those have a kind of an interesting design, because most of the more likely fraud offences, like the forgery offence and the tax fraud, are intentional offences, but those other offences, those newer ones, also include negligence as to the information's relevance. So it's a pro parte dolus pro parte culpa offence. So there is dolus as to the provision of the information, and there can be negligence as to whether you should suspect that the information provided is relevant as to some kind of decision that is to be made. There's quite a bit of a lowering of the standard of culpability there, which lowers the criminal liability threshold slightly. So that's pre-existing legislation. The government thought they could get away with that, but that was not really true, because, well, as we've discussed earlier, the Commission sent out a notice of infringement in the first step of that procedure in 2022. It's very interesting to read in the parliamentary discussions that the government sent on this process to our domestic parliament, because basically the government says, well, the Commission couldn't really explain why they were not satisfied with our implementing act. So they blamed actually the Commission for not making clear what the problem was. The government understood the notification as an indication that the Dutch legislation did not cover oral fraud, only written fraud. And that's because, well, obviously, the offence of forgery in writing, falseness in writing, has that as a required element. So you have to have that written element to be able to be covered by Article 225. And the Commission said, well, what if you provide information in an oral way, not in writing? Then there could be some cases that are not covered. Well, the government tried to find out whether that is true, and in the end, they said, okay, so probably there are a couple of cases of oral commission of revenue fraud that are not covered yet by our offences. Procurement-related fraud was covered if that would be somehow committed in an oral form. Of course, it's a bit difficult to understand how that would work, this oral fraud, but perhaps it's possible. So basically, Articles 3, 2C and D were not covered according to the government if committed in an oral form. Now then, the government proposed a bill to Parliament to expand those Articles 227A and B, so those early 2000s offences, to expand them with fraud by other means. And then the discussions ensued with the Commission because they got informed about that proposed bill, and the Commission basically said, well, it still doesn't really fit because the proposed articles don't really run parallel to the PIF directive. And there's a distinction there between what is actually in the bill and what is in the directive. And it is a bit difficult to understand why. I think it is because the Dutch offense requires that you give the presentation to some kind of authority that is there to decide. So there's an institutional element. You have to hand it to an authority, the information, and that institutional element is absent in the directive. So I think that is what the Commission meant, but it is very unclear if you read in parliamentary papers what is actually behind that discussion. I think that was it. Somehow the government and the Commission came to an understanding that the proposed amendment would not cover the directive, and therefore the government changed the bill when it was in Parliament, and then proposed an entirely new article, 227C, which is specific for EU fraud, and that has as an element that it excludes fraud in the form of falseness in writing. So if it is covered by Article 225, it cannot be covered by 227C. And further, the structure is a bit the same as the other fraud offences that we have. It includes two variants: submitting false information and omitting to provide relevant information. Only an intentional variant, and they're now in the criminal code since the 1st of October last year. So less than a year, it's now in force, and that is the result of this process of the start of the infringement proceeding. I have a couple of remarks on that in general. So what is always striking, and I experience that quite a lot when talking to people in other countries about our system, is that this default offense of forgery or falseness in writing is such a bit of a remarkable starting point. And we've heard from Professor Zimmermann that in Germany you have Betrug, that is the basic offense, and from that the system is adapted. We start with another kind of offense, providing false information in documents, and then we try to build upon that or our implementation obligations. There is in the Dutch legislature a very strong preference for using pre-existing offences. They're extremely tenacious in that. So with any topic, right? So not just in the PIF directive, but for any topic, the legislator just wants to maintain the structures that are in place, that are in the code, and just present that as sufficient for transposition. In this file, we have seen that strategy was eventually unsuccessful. Now there is a mix of pre-existing legislation, which was already quite a combination, quite a composite structure, a mix of that with a new offense. The funny thing is that that new offense, Article 227C, that can really be mistaken as a standard offense. In my law book, I just received the new version for this year a couple of weeks ago. The publisher actually places a little marker in the next to each article. So this the publisher has put the label on this offense called fraud with EU funds. It's completely wrong, right? If you have a fraud with EU funds case, chances are 99.9% that this article will not apply, because it excludes the offense of forgery in writing, and that is probably what will cover it, and not this particular new offense, because it is only covering oral fraud. Well, I don't think that happens very often. So the label of fraud with EU funds is completely mistaken for this offense. Now, it has a bit of a lower maximum penalty, 4 years, not 6, because that was the implementation obligation. So it gets that. There's no top on that. There's no negligence variant. It's purely intentional, which otherwise also could have extended the scope. And it is yet another offense on top of the existing one. So there's a proliferation of coordination issues. We get issues of concurrence. It can easily be seen that there can be a concurrence, particularly with 227C and the further ones, the earlier ones, A and B. That can be an issue of whether this is a lex specialis to one of the other offences. And there is quite a difficult combination now between these offences and the question of EPO competence versus the domestic authorities in the rules, particularly where you have the ancillary offences with the same or a lower penalty. And this looks like a basic offence, but this is basically not applicable in most of the cases. And that can make it difficult to ascertain that competence and to decide on whether the EPO or the domestic authorities are competent. And that decision making currently is now in the hands of the public prosecutor's office, the domestic public prosecutor's office, that cannot, when they need to interpret the exact nature of Article 25 of the EPO regulation, refer any cases to Luxembourg because they are not a court. So this does pose the question. It leaves me with a very uneasy feeling. Our legislator tends to prefer pre-existing laws. They don't manage in the end. This is not the only case in which, in the end, a second round for transposition is necessary. And then new specific provisions have to be adopted. Shouldn't we just go on and establish self-standing offences if there is a new directive, because we can't abide with that by using pre-existing laws? I think there are some benefits for that. It clarifies when the authorities apply EU law. You just know on the basis of the article that the defendant is charged with, this is within agreement of EU law. The charter will apply. It's a very more clear-cut situation, particularly also when the structure of the offence varies. In this case, there's no negligence variant. If you would prosecute a negligent fraud case under the other articles, you would also fall outside the scope of EU law. It would not be an implementation, but it would be possible to fit that under the same offence as you would otherwise use for a fraud case. That could make the situation much clearer. And in the end, you have to yield anyway. So maybe just start with that first. But I can also see the drawbacks of that, because that would the number of provisions would explode. So that can also be not that attractive. But I think it's an important reminder that it is difficult to use pre-existing laws, particularly when you have such a bit of an outlier situation with this offence of forgery, falsehoods in writing. So that was actually one of the points that I would like to raise coming out of this procedure. So I hope that I think that was it. Thanks for your attention, and look forward to the discussion.
So thank you, Pim. I want to raise just two questions. First of all, for what I understood, so okay, because of also the very clear criticism that you expressed concerning, I mean, the actual situation, the legal context in the Netherlands. So you would suggest the need for somehow a new reform in the sense of a overall or more coherent approach instead of for what I understood. So would you suggest, which would be your suggestion, recommendation to your national legislator in order to have a more compliant law with the obligation directive? This is my first question. And the second question, just to be linked with what we were discussing this morning, would you think that the adoption of separated law, specific law concerning EU interest, in this case, EU financial history, would be the best way to go on with implementation of EU obligation?
I wouldn't be in favor of adopting specific laws. I would be very happy if the criminal code is used, but some provisions in there could be adopted. Our legislator, when implementing the PIF Convention in 1995, was perfectly happy with adopting a provision on misapplication of international funds. That wasn't there before, so that was introduced back then. And I would think that particularly if you realize for yourself that you have such an outlier situation in which you really don't fit in the whole European picture in terms of how the criminal code is structured, yeah, maybe you should not just go on in that direction, but try to take a step back and try to see, well, maybe we should include a self-standing fraud offense and not go on with that forgery offense as the basic offense, which is very typical. The Supreme Court accepted that intellectual falseness years ago, but still has been criticized for that. Also because the prison sentence is quite high, 6 years, for just writing something down on an existing form that perhaps is not really true. It's quite a high maximum penalty for that. Yeah, so I think that we should definitely take a bit of a step back and introduce a self-standing offense. And the offense that we have now, Article 227C, says it's a specific EU fraud offense, but it never applies because it can only apply when you commit it orally. It's stupid.
Okay, thank you. Now, I mean, I go back to, I don't know if we can now connect to Mr. Kalinescu. Can you connect?
Can you hear me now?
Yeah.
Hello. Oh, okay. Good to see you.
Yes, I can hear, but okay. Now we can hear and also see you on the screen.
Thank you very much.
So thank you for joining the workshop, and you have the floor. Thank you.
Thank you very much. I will try to see if I can share presentation. Just let's see. Well, should have a PowerPoint, but it doesn't let me show it. This is pity.
I have authorized you, so you should be able to share the PowerPoint.
Amalia, please authorize me also. So
but I think I do. You are already authorized. You too.
Should Let's see now.
Okay, maybe now.
Okay, now it's visible?
Just, yes.
Oh, okay. Harsh portions of the intervention.
With the now we can hear. There was a moment we could not hear you.
Okay, now can you hear me?
Yes, we are.
Okay. So I attended partially the meeting, and I took stock of the interventions focusing on the PIV directive. So even though we don't have the Romanian intervention on the national experience, I think many of the insights would have been similar with what we just heard from our previous colleagues and speakers. So I want to a different discussion by referring to something that we see very important from our side. And this is the bridge that we want to see happening among various instruments that we have at EU and international level, especially those focusing on tracing and recovering criminal assets. Plenty of legislation and institutions in charge with this. We are still very far from being successful. We still have reports in UN stating that 1% of illicit financial. We have few we have stepped forward with the new directive on asset recovery and also the establishment of the anti-money laundering agency. An important area.
I think you have problem of connection because at least I cannot really listen to all what you say.
Yes, me too.
Amelia, lei ha sentito bene?
No, interrotta la voce.
Ah. No, now we completely miss you. We lost you. They both disappeared. No. One of them is still there.
Sorry for this. We have some problems with the internet here. We try to change the entire system, so there are some problems. 1 second, if I will continue the presentation, or my director will enter again. So I will continue the presentation. It's another. Do you see it?
Yes, we can now.
And the next slide. Yes, the purpose of the presentation.
No, the first. Yes, the second one. Yes, but we cannot see you, Edward. However, we see the presentation.
Oh, it's okay.
Okay.
So what we try with this presentation is to establish the links between these three key legal instruments and highlight their combined impact on ARO and AMO's competence, and of course our experience through ANABI. So in our opinion, these instruments should not be seen as isolated legal frameworks, but as complementary pillars of a single policy goal, depriving criminals of their illicit gains. Even if the legal bases differ, all three instruments serve the same ultimate goal, the same dismantling criminal financial power and returning value to the society. This was the slide which was in the my director presentation. At the moment, countries recover less than 1%. It's a total overview, but of course, some of the offenses are in the competence of EPPO or in our legislation, DNA and OLAF. But in the same time, we have improvements with the new directive on asset recovery and improvements for the other states within Council of Europe. I want to express, to resume the three instruments. In our opinion, the PIF directive defines serious offenses, hardening the EU budget, harmonized criminal definitions, sanctions, limitation of periods, strengthen the role of the European Public Prosecutor Office. So it is not about asset recovery directly, but it creates the legal foundation that triggers confiscation proceedings. For example, EPPO investigations on PIF offenses often lead to freezing and confiscation orders, which later involve AROs and AMOs. So while ANABI does not apply the directive directly, of course, it cannot be applied directly because it's a directive, it's not a regulation, but the offenses which are transposed in our legislation, we don't apply them at the first stage, but our work depends on its enforcement. Why it matters for the asset recovery provides the legal basis that triggers freezing and confiscation proceedings. Also, we have the Article 10, which is directly linked to the Directive 42 from 2014. Yes, the Directive 42 will be changed with the new directive, but the same is the same institution as the freezing orders and the confiscation orders, which are the instruments to cooperate to have a final confiscation at the end of the trial. EPPO lead PIF cases generate high value cross-border seizures. AROs become operationally involved to identify the assets, reduce legal fragmentation, faster and more consistent asset tracing across jurisdictions, and also links national authorities, DNA, OLAF correspondence with AROs and AMOs. So it creates the legal spark that activates AMO and ARO's work. From the point of view of the directive, which need to be transposed until the next year. As you know, we had another project with Professor Maugeri and Amalia. It's a recover project. So there it was a very intense activity under the regulation 1805 and this new directive. I will not present the new directive, but I need to underline that ARO and AMO will have powerful attributions. All the states will have an ARO and AMO, so all the states will need to cooperate to identify assets and to execute the immediate measures, the freezing orders, and confiscation orders. There is another redefinition. It's another way to regulate the confiscation. It's an integrated way to this institution, which is regulated as a confiscation from a third party, extended confiscation, non-conviction based confiscation, and a new type of confiscation, confiscation of the unexplained wealth. And I think because we speak about PIF directive, there are offenses which they are very well linked to the extended confiscation and the confiscation of unexplained wealth, because there are offenses where it's about money in the last place. After the substantial law, which is in PIF directive, and procedural law, to say so, to identify and confiscate the actives, which is in EU directive from 2024, we have a new instrument, the Council of Europe, Strasbourg Convention, and the Warsaw Convention, in which we'll have a new protocol, which will extend the directive, which will extend the standards from the new directive from confiscation and asset recovery to the other European states which are not in European Union. So provisions will enhance certainty and consistency in the sharing of confiscated assets between state parties, provisions to ensure efficient and effective management of seized, confiscated, and repatriated assets, provisions to facilitate the introduction of non-conviction-based confiscation and extend confiscation, and other issues which deemed to be of consequences to strengthen cooperation among parties with respect to asset recovery. These are the participants. My director, I'm sorry again for this situation. He is the head of the negotiation protocol, and in the what we want to present is this slide. I think this is the conclusion: bridging map from the crime to recovery. So the PIF directive defines serious offenses and triggers asset tracing. After that, we'll have these operational powers to tracing, freezing, managing, and confiscated assets. AROS empowered DAMOS established non-conviction-based confiscation and extend confiscation. So we'll have a full recovery life cycle, and after that, at the European level, and after that to the non-European Union states. So we'll have a integrated framework with these three instruments. Why this matters for AROS and DAMOS? Border mandate, I think it will strengthen and it strengthened already the international cooperation. Need for autonomy and resources to develop these activities, which are big actors like DNA in Romania and ANABI and OLAF. ARO and DAMOS are becoming strategic actors, not just technical support units. They must deliver tangible results and preserve asset value while under legal constraints. So briefly, we'll make a little presentation about ARO and DAMO Romania, one-stop shop. As I said, ANABI is ARO. We have the powers to exchange information and to have the power to sign the asset sharing agreements between states. We also have the powers of AMO. We administrate the assets under the trial. We have powers in social and public reuse, a mechanism to support the crime prevention, and also we sharing the best practices with magistrates, mainly in cooperation with the National Institute of Magistracy. I will show you only some assets which are from this type of offenses from the PIF directive. As you can see, there are luxury cars, luxury watches, and some stocks. We also have the power to sell it in the trial. The selling it's on we have it online. We also have in management the crypto actives, and of course, because it's about bribe in some cases under the PIF directives, we watch the new trends to bribe or someone or to take bribe in crypto actives, and this is a very good point to tackle now, because we try to figure out how to manage them, how to identify them, how to freezing this type of assets. We also have an electronic register, and all of that will be inserted there, and we can recreate only for some offenses, like PIF offenses, and the program will give us the numbers only for that offenses. For example, if you want only the PIF offenses, you can took them the information from this instrument. So the opportunities with the of these three instruments working together is EU funding, and this project is representative about the EU funding in this matter. And in the end, we have the opportunity to strengthen the ARO and AMO capacity and influence policy debates. For policy recommendation, early tracing mechanism for this type of offenses, legal authority for AMOs, data interoperability, and the asset management in procedure. So in the way forward, we want from fragmented to coherent life cycle of the assets, from reactive to proactive activity in the field of identify assets and confiscate them, and from isolated to integrated framework with this combination of three instruments: the PIF directive, the new directive of asset recovery and confiscation, and the new protocol of Warsaw Convention. Success depends, in our opinion, about the robust ARO and AMO's activity. Thank you very much, and sorry for this interruption. And I hope it was okay from you, our presentation.
Thank you very much. I think it's interesting to know about your engagement in such a, I would say, in such a coherent, trying to, at least to develop such a coherent approach, which at the end of the day should be actually the approach also at EU level, or in all the national legal order, and try to actually complement, I mean, to consider and to make implementation of international and European piece of legislation as complementary ones. I will go to give the floor to Lorenzo Rapisarda, which is his PhD student at the University of Catania, who is the author of a publication, one of the publication of this connected to this work package concerning the role of the EPO in the protection of the EU financial interest. Lorenzo, you have the floor.
Thank you, Professor Sicurella, and good afternoon, everyone. Can you hear me clearly?
Sì, Lorenzo, io la vedo e la sento, quindi immagino anche gli altri.
I would like to ask to the previous speaker to interrupt the share screening, because I need to present my PowerPoint.
But I don't see the presentation of the Romanian expert, Lorenzo. Maybe you can. You already can share your PowerPoint.
Okay, in my screen, it is still going. I don't know. I will try to share my screen anyway.
Okay.
I don't know. Microsoft Teams right now is stopping me because it says that the presentation is still going on. I can try to leave the meeting and join again.
I don't know. I can text Mr. Lelai. Edward, if you hear me, can you stop the sharing of your presentation?
Okay, I'm sorry for this time loss. It looks okay now. Okay.
Try to share.
Perfect. Can you see my screen?
Okay. Perfect.
Okay, the presentation is on. Okay, so thank you again. I would like to thank the organizers for allowing me to participate today and for involving me in the research project in the first place. Of course, since I am the last one to speak today, I know that everyone here is tired, even if the conference was very, very rich. So I will stay within the time that I have been given, and also I will try to finish a few minutes early. As Professor Sicurella said, and as it is indicated in the events program, my presentation today is about an article of which I am the author. The article hasn't been published yet, but it's only a matter of days. It will be published very, very soon on the New Journal of European Criminal Law. The events program indicates only in very general terms, which is the topic of the article. So in order to specify it, you would like to start from the title that is here shared on the screen. The title of the article is "The EPPO Between Union Law and National Systems: Critical Reflections on a Hybrid Enforcement Model." We have had already other contributions today from two European delegated prosecutors and also Dr. Venegoni, the Italian prosecutor, that have analyzed different areas of the EPPO scope and legal framework. We already we all know, we have already heard that the EPPO regulation does not establish a complete and autonomous legal framework. Instead, it is a hybrid model, as was defined already by scholars way more authoritative than me, for example, Professor Ligeti, and because the legal framework lies on the interconnection interconnection between European Union law, so the regulation itself, and the national systems, also with the implementation, the national implementation law to the regulation. The fact is that this hybrid model creates some gray areas. I have tried to analyze some of them in the article, but today, for time limits reasons, I will only focus on one of them. During the past days, I was thinking about which topic to present today. I was thinking about Article 31, so the legal framework of the transnational investigations of the EPPO, because I mean, it's the core issue of the EPPO regulation. But luckily, I didn't choose it because also Dr. Benegoni told us about that matter. So I preferred to focus on another matter that is related to another provision of the EPPO regulation, which is Article 42, and in particular, Article 42, paragraph 1. Which states that procedural acts of the EPPO that are intended to produce legal effects vis-à-vis third parties shall be subject to review by the competent national courts in accordance with the requirements and procedures laid down by national law. Basically, this provision here has given an exceptional competence to the national courts and judges to review the procedural acts of the EPPO. Why is it exceptional? Because if we had to apply the principles that derive from EU law, it should have been the Court of Justice to be competent to conduct this review. But for several reasons that we're not going to analyze here today, but that have been analyzed by scholars in very interesting articles during the past years, the European legislator has made a different choice and has basically, we can say, appointed the national courts to conduct this review. The fact is that, of course, since it is an exceptional competence, there are some boundaries and normative limits indicated by the norm, which at the beginning appeared quite clear, but actually they were not, because last April, the Court of Justice delivered a preliminary ruling on interpreting the first paragraph of Article 42 of the EPPO regulation. And the preliminary request was issued by a Spanish court, but we are not going to focus on the case that lies behind the preliminary request. We are just going to focus on the interpretation that the court has given of Article 42, paragraph 1. And this is functional to another issue that I will analyze further. The Court of Justice first stressed that the reference to member states, the member states' law, is only partial. Because it only applies to the modalities through which national systems give procedural effect to judicial review, while, on the contrary, the notion of procedural acts of the EPPO intended to produce legal effects vis-à-vis third parties is an autonomous concept of European law. So consequently, it needs an autonomous and more in particular, uniform interpretation throughout the Union. Now, by referring to the recital 87 of the regulation, the court emphasized that the procedural acts are those acts undertaken by the EPPO in the course of its investigations. Okay, this quite seems obvious to us, but further, as regards the expression producing effects vis-a-vis third parties, the court noticed that the Advocate General before the court, like all the other parties of the judgment, noticed that it is the same as in Article 263 of the TFEU, which regulates annulment actions before the court itself. And the court drew from the relevant case and held that these must be procedural acts, now in reading paragraph 63, producing legal effects of which are binding on and capable of affecting the interest of a natural or a legal person, bringing about a distinct change in their legal position. But the court further noted, now I go to paragraph 67, that in order to determine in a given case whether the contested act is intended to produce binding legal effects, it is necessary to examine the substance of the act and to assess its effects in the light of objective criteria, such as the content of the act in question, taking into account as appropriate the context in which it was adopted and the power of the EU institution, body, office, or agency which adopted it. Following at the same time, the court recalled that the regulation does not intend to interfere with the principle of procedural autonomy of the member states. So while the member states are bound to guarantee the right to effective judicial protection under Article 42 of the regulation, they remain free to define the procedural modalities of judicial remedies. This means that the principle of effectiveness does not necessarily require the establishment of a direct judicial remedy against each procedural act of the EPPO. Instead, effective protection may also be ensured by incidental review carried out by the judge competent of the case. But in compliance with the principle of equivalence, remedies must not be less favorable than those provided for comparable domestic situations. Now, let's keep in mind this principle, the principle that are in the judgment, because now I would like to ask to the audience a question. Does the decision of the EPPO to initiate or to advocate an investigation constitute a procedural act producing effects vis-a-vis third parties within the meaning of Article 42? And I raise this point because, in my view, the Italian system is inconsistent with Article 42 of the regulation, but also with Article 47 of the Charter of Fundamental Rights, since in the Italian system there is no possibility there is no possibility for parties other than the EPPO and the national prosecutors to obtain a judicial review of the EPPO's exercise of competence, the proper exercise of competence. I want to clarify this point, and we have to focus for a second on the Italian adaptation law to the regulation, to the EPPO regulation, which is the legislative decree number 9 year 2021. Article 9, let's focus on the second paragraph, states that the prosecutorial functions extend across the entire national territory. So a European delegated prosecutor in Palermo, for example, can exercise its functions also in another region, for example, in Veneto, in Lombardia, or Piemonte. because the competence of the European delegated prosecutors basically is nationwide. Moreover, Article 16, which is on the right, of the same decree designates the Prosecutor General at the Court of Cassation as the competent authority to decide conflicts of competence between the EPPO and the national prosecutors. Also, the second paragraph recalls some norms from the Criminal Procedure Code, which are applicable to the procedure, but there is also they are recalled with a compatibility clause. So it means that it's not for granted that they are applicable also to the resolution of conflicts of competence pursuant to Article 16. This is a concrete issue, since now focusing on Article 54 quater, the Prosecutor General has stated in the past in 2 occasions that this norm is not applicable in this context, in this matter. But what does Article 54 quater states? In purely domestic cases that do not involve EPPO, it allows the suspects and other parties and their attorneys during the preliminary investigation stage to request that the case is transferred to the prosecutor attached to the competent judge when they believe that the offense falls under the jurisdiction of a different judge than the one before whom the prosecutor is proceeding. But it can happen only on the grounds of territorial or connection-based reasons. As I said, the Prosecutor General has already stated that this norm is not applicable in pursuant to Article 16. The Prosecutor General basically has said that it cannot be invoked where the functional competence of the prosecuting authority is challenged as because what is contested are the very grounds of competence of the EPPO, and this would blur the lines between jurisdictional relations and relations between different prosecutions offices. Indeed, in the first field, when jurisdictional relations are involved, the functional competence issues can be raised. It cannot happen in the second case because in Italy, at least in principle, the prosecutors are competent for every kind of felony of offense of crime. But if, as I believe, the EPPO's decision to initiate or to take over an investigation constitutes a procedural act, the lack of a legal remedy in the Italian law allowing the review of the exercise of competence by the EPPO upon requests of subjects other than the prosecutors, the European one or the national one, conflicts both with Article 42 and with Article 47 of the Charter. I also believe that these are acts that to produce effects. I'm sorry, there is an ambulance. These are acts that produce effects on these subjects, on these parties, especially the suspects, whether because it makes a difference if the prosecuting authority is the EPPO or the national prosecutor. This is a difference that matters, especially when we are talking about cross-border cases, because we know, Dr. Benegoni talked today about Article 31, we know that the system, the investigation system based on Article 31 has many differences from the ordinary judicial cooperation instruments that can be used when the investigation is conducted by a national prosecutor. So I think that such acts produce binding legal effects which are capable of affecting the interests of a natural or a legal person by bringing about a distinct change in their legal position. So I think that the principles that were stated by the Court of Justice are fully applicable to in this matter. And the issue is even more pressing considering the very broad interpretation that also the Court of Cassation has given of the EPPO regulation in the parts where the competence of the EPPO itself is built, basically, because, for instance, in cases concerning the VAT frauds, in cases where the competence of the EPPO was doubtful, the court asserted that under Article 26, paragraph 4 of the EPPO regulation, the competence may in any case be exercised whenever the EPPO is better placed to conduct investigation. But the problem is that this is not a residual or generalized clause to extend the EPPO investigation. It is related to a specific case, so it must be narrowly interpreted. And I think it cannot be accepted such a broad interpretation of the regulation, especially since an exclusive competence of the EPPO hasn't been chosen during the negotiation of the regulation, and instead a shared model of competence has been chosen in the final text of the regulation. I don't know how many times do I still have, because I may conclude now or make some closing remarks.
I mean, if you wish so, I mean, in principle, you actually match exactly the time in this moment. So maybe a couple of minutes if you wish to just draw some conclusions.
Okay, yeah, just some concluding remarks, because as I said, I already believe that there is an inconsistency with the Article 42 and Article 47, even if I am not sure that the principle of equivalence is at stake. Because the Prosecutor General at the Court of Cassation is correct when it states that the Italian legal system does not provide a procedural mechanism to challenge the functional competence of a public prosecutor. And I already said the reason before. So the Article 54 quater that that is still shared in the screen is a problem that does not discipline a case that is strictly the same as the one that I was talking about before, that I presented before. So even if I'm quite sure of the conclusions that about the inconsistencies, the applicability of the principle of equivalence might be questioned further, but also might be challenged. And with this, I have concluded my presentation today, and for the other issues that I analyzed, the article will be published very, very soon, and I would like to thank the audience for the attention.
Thank you, Lorenzo. And I think it's, I mean, it was the point, I mean, the several points that you raised, that you analyze in the article are really important. And I would say that in addition to the point concerning admissibility of evidence that you decided not to deal with because it was already dealt with by, Dr. Venegoni, I think also the question you raised about the some acts of the EPPO, whether if they can be considered as procedural acts. And also there are some interesting points that now are arising because we are going on with cases that were first investigated by the EPPO, that, for example, concern, for example, the fact that we say that a national I would say national judgments are dealt with following the national rules, national procedure, but there are new things that appeared. For example, exactly how to deal, whether the national judge is competent to deal with the act from the EPPO, in the sense of the national representative when going to the court. This was one. This is a question which is actually something that the regulation does deal with. That so far was not very much discussed, but now that we are going through, judgment process at national level, I think we will have many other questions coming out that maybe would also push for some rules also, at least on the moment, at the stage of the connection of the shifting from the investigation stage into the decision or the debate, the discussion stage. This will be quite sensitive. It's not just the question of the admissibility of evidence. There are many other questions. I know it's pretty late. It was quite, demanding, the participation to this workshop. But please, if any of you have a question to put to Lorenzo Rapisarda or to other speakers in the afternoon session, if they are still there. Any question? In any case, as you understand, this is just a workshop. All the main topics will be again discussed with new also speakers as well in the final conference. So not only fraud, but also corruption, confiscation, etc. So any further, I would say, reflection on that point from the speakers who presented their contribution today will be very welcomed, also in the perspective of the conference that will be held in February to close the first year of the project. If I don't know, Amalia, if you want to say anything, no, so I can close this workshop. Okay. I thank again all the speakers, and please, I reiterate the recommendation to send presentation that you shared today, or for speakers who did not present the written contribution so far. They are really warmly invited to do that, because we are required to send all the, I would say, the contribution related to this work package also to the commission. So thank you to all, and have a nice evening, and looking forward to see next occasion. See you.
See you. Bye-bye.
Bye, everybody. Thank you again. Ciao. Bye.
Bye.
Bye.